In this video, we will review the structures of nonprofit organizations in California. This form of business is a legal entity organized for purposes other than generating profit, where any revenue must be used to further the organization's objectives rather than being distributed to shareholders or members. Key types in California: public benefit corporations. The most common type serving charitable, educational, religious, literary, or scientific purposes. Examples include academic institutions, charities, and social welfare organizations. Religious corporations. Organized primarily for religious purposes. Mutual benefit corporations. Operate for the benefit of their members, such as homeowners associations, social clubs, or professional organizations. Formation requirements. File articles of incorporation with the California Secretary of State. Obtain an employer identification number, EIN, from the IRS. Register with the California Attorney General's Registry of Charitable Trusts if charitable. Create bylaws governing internal operations. And finally, appoint a board of directors. Tax considerations. Must apply separately for tax-exempt status with both the IRS using Form 1023 or 1023-EZ and the California Franchise Tax Board. If approved, the organization will be exempt from federal income tax under Section 501(c)(3) and California state income tax. However, it must still file annual returns such as Form 990 series federally and Form 199 in California. Additionally, the organization may need to pay taxes on unrelated business income. Alright, let's talk about the operational requirements. To begin with, you must maintain accurate financial records. It's also essential to hold regular board meetings and keep minutes of those meetings. Additionally, you need to file annual reports with the Secretary of State. If your organization is charitable, you'll have to submit annual financial reports to the Attorney General. Don't forget to comply with public disclosure requirements and make sure to maintain appropriate records for tax purposes. Now, let's move on to some important restrictions. First and foremost, you cannot distribute profits to members or directors. Your assets must be used for charitable or nonprofit purposes. If you're a 501(c)(3), your political activity is limited. It's crucial to pay reasonable compensation and avoid excessive salaries. Finally, upon dissolution, your assets must be distributed to another nonprofit. In California, you can operate a nonprofit in several legal forms, not just as a corporation. Here are the main options. Unincorporated association. The simplest form of nonprofit organization, created when people join together for a common non-business purpose. No formal filing is required with the state. It can still apply for tax-exempt status with the IRS and state. Members have less liability protection than corporations, often used by small volunteer groups or temporary organizations. Charitable trust, created when assets are set aside for charitable purposes, established through a trust document, requires registration with the Attorney General, governed by trust law rather than corporate law, common for foundations and endowments. It has a more rigid structure than corporations. Limited liability company or LLC can be nonprofit if all members are tax-exempt organizations. Less common but possible under California law. Must be organized and operated exclusively for nonprofit purposes. It has a more flexible management structure than corporations. Cannot directly receive 501(c)(3) status from the IRS, usually used as a subsidiary of another nonprofit. Fiscal sponsorship. It's not a legal form itself but allows operating under another nonprofit's legal status. It's particularly good for new or temporary projects as it reduces the administrative burden. With fiscal sponsorship, you can receive tax-deductible donations without having your own 501(c)(3) status. However, you must have a written agreement with the sponsor and the sponsor maintains legal and financial control. Each form has different advantages and considerations regarding liability protection, administrative requirements, formation costs, management flexibility, fundraising ability, and tax treatment. For hospitals in California, the most appropriate and standard legal structure is a non-profit corporation rather than the alternative forms I mentioned. Here's why. Hospitals handle significant financial transactions, employ large numbers of staff, and have complex regulatory requirements. They deal with substantial liability risks and need robust governance structures. The California Health and Safety Code has specific requirements for hospital licensure. Hospitals must comply with Medicare and Medicaid certification requirements, need extensive corporate documentation for accreditation, are required to maintain significant insurance coverage, and must demonstrate financial stability. Practical limitations. Unincorporated associations are too risky given healthcare liability. Charitable trusts lack the operational flexibility needed. LLCs typically can't meet healthcare regulatory requirements. Fiscal sponsorship isn't suitable for the scale and permanence of hospital operations. Most hospitals, therefore, operate as either 1. Non-profit corporations, often public benefit corporations, 2. For-profit corporations, or 3. Government entities. The non-profit corporate structure provides clear governance structure required by regulators, liability protection for board and officers, ability to issue tax-exempt bonds, framework for complex compliance requirements, and structure for medical staff organization. In California, nonprofit organizations can take several legal forms, with the nonprofit corporation being the most common and structured option. While alternatives like unincorporated associations, charitable trusts, LLCs, and fiscal sponsorships exist, each offering different levels of flexibility and administrative requirements, they are typically suited for more minor or temporary organizations with more straightforward operational needs. Due to regulatory requirements and operational complexities, the nonprofit corporation structure is essentially mandatory for complex organizations like hospitals. This format provides the framework for managing substantial financial transactions, employee relationships, and healthcare compliance while offering liability protection and the ability to handle complex governance structures. The corporate structure also enables hospitals to issue tax-exempt bonds and maintain the robust documentation required for healthcare accreditation and regulatory compliance. Please read the description to know the sources. If you like this type of video, consider subscribing to the channel. Thank you for watching.